G'day everyone, and welcome to the second video in week 10 of our Legal Ethics and Trust Accounting course. This week we're looking at the duties that we as practitioners owe to one another as colleagues and officers of the court working together to assist the court to bring justice, even when we're on opposite sides of a matter. We've already spoken about the duty to be courteous to one another. In this video, we're going to get a little more specific and discuss the duty not to take advantage of our opponent's mistakes. Rule 30.1 in the Australian Solicitors Conduct Rules says a solicitor must not take unfair advantage of the obvious error of another solicitor or other person if to do so would obtain for a client a benefit which has no supportable foundation in law or fact. Now, there's a bit to break down in this rule, isn't there? It's certainly not as simple as a sheer statement that you can't take advantage of another solicitor's error. Let's work through it. Our starting position has to be, quite obviously, the fact that we're all participants in an adversarial system of law. Our entire system is premised on the idea that each litigant has a legal representative, and those legal representatives will conduct a contest where they oppose one another and each side tries to defeat the other. Your job as a legal representative is not simply to show that your client is right, it's also to show that your opponent is wrong. It's not your job to ensure that your opponent's case is put at its highest. That's the job of the opposing solicitor or opposing counsel. And so if your opponent makes mistakes in their understanding of the law, or mistakes in their handling of a witness, or mistakes in the presentation of their arguments, then you are fully entitled to gleefully take every possible advantage. Otherwise, it'd hardly be an adversarial system at all. This is why the rule only forbids taking unfair advantage of your opponent's error. But that, of course, opens up an entirely separate can of worms. What do we mean by an unfair advantage? In general terms, it can be helpful to divide our opposition's potential errors into errors of three different types and deal with each of those separately. So we're going to look at errors relating to law, errors of tactics, and errors of fact. Let's start with errors of law. Now, obviously, our starting point is that you're often going to disagree with your opponent about the interpretation of the law. If everyone agreed about the meaning of the law, then there'd be far fewer trials. And so if you think your opponent has made a mistake in relation to their understanding of the law, you're not under any obligation to correct that mistake. In fact, it's usually regarded as a considerable discourtesy for one practitioner to presume to instruct another practitioner as to the meaning of the law. So you would never write to another practitioner and say, with respect, you appear to misunderstand the relevant legislation, and then follow it up with your own explanation. That's just not done. At the same time, however, it's part of the duty of any lawyer to ensure that the issues which come to trial are the true issues in dispute. And it's also part of the duty of any lawyer to explore the opportunities for settlement prior to trial. Both of these things will often require you to advocate to your client and for your client's position. So you might well say, in our client's view, the statute has the following meaning. We would point to the cases of X and Y and M and N in support of our client's views. Can you see the subtle difference? You're not lecturing your opponent in the second case, you're simply stating your client's view of the law and the basis for that view. Your opponent is left completely free to disagree if they wish. There's a difference between advocacy and lecturing. So you're not under any obligation not to take advantage of your opponent's mistake regarding the law, but at the same time, it's in your client's interests and it's consistent with your own ethical duties to advise your opponents of your client's view of the relevant legal issues. This should be done cautiously without lecturing. Finally, on this point, remember that you also have the duty of candour. If your opponent makes a mistake by failing to refer in court to a significant authority that supports their position, you are not entitled to remain silent and let the court proceed in ignorance of that authority. Still, in general terms, you're not required to refrain from taking advantage of your opponent's erroneous understanding of the law. Stick it to them. Next, your opponent might well make a tactical mistake. For instance, if you were at trial, your opponent might be examining one of their witnesses, and you might be very worried about this witness because there's a line of questioning which, if they follow it, it's going to make your case much more difficult. Lo and behold, your opponent does not follow that line of questions. Hallelujah! You're fully entitled to take that error and run with it, exploit it to its fullest. You're certainly not obliged to send your opponent a note up the table to say, hey, why don't you ask a bunch of questions about X, Y, and Z? Tactics are a very personal thing to be determined by each advocate, exercising their individual decision-making before the court. What you see as a mistake might well be a very deliberate decision by your opponent. So you're allowed to take advantage of your opponent's errors of law. You're allowed to take advantage of your opponent's errors of tactics. The real issue emerges in relation to errors of fact. Now, even with errors of fact, things can be a bit complicated. For starters, remember that your opponent will be basing their conduct on the instructions that they receive from their client. Bear in mind that we have an ethical duty to our client to act within instructions. And so if our client has instructed us that the contract price was $11,000 plus GST, and our opponent is insisting that the price was $11,000 including GST, this may not be an error on their part. It may simply reflect the fact that they're operating with different instructions as to the facts. Again, we would ordinarily get instructions to point out anything where, as far as our client is concerned, the other side misunderstands the facts. If we can convince the other side that they're wrong about those facts, well, there may not be need for a trial at all. But if our opponent insists on proceeding on a factual basis that is incorrect, it's not improper for us to take advantage of that and to assemble evidence to ensure that the court completely rejects their position. So by this time you're scratching your head, right? I mean, I've told you that you're allowed to take advantage of your opponent's mistakes as to the law, you're allowed to take advantage of their tactical mistakes, and you're allowed to take advantage of your opponent's erroneous understanding of the facts of a matter. So what does the rule actually apply to then? What mistakes are we not allowed to take advantage of? Well, let's say that you're exchanging emails with your opponent regarding the preparation of affidavits, and your client says, we've got plenty of time to get these signed and filed before the next court appearance on the 10th of January. You know for certain that the orders say the next court appearance is to be on the 8th of January. Now, it might be to your client's advantage to have your opponent fail to turn up on the day of the hearing, but it would be ethically wrong for you to take advantage of this error. You would be obliged to respond to the email and point out that they've got the date wrong and that in fact the appearance is on the 8th. Do you see? This is an error and it would be most improper to take advantage of it. The best example I can give is a case called Chamberlain and the Law Society of the ACT. In that case, a lawyer for the tax office mistakenly issued a writ claiming $25,557.92 instead of the proper amount, $255,579.20. So basically they claimed only 10% of the actual claim. They left off a zero. Chamberlain knew this was an error, but instead of advising his opponent of the error, he rushed to ensure his client agreed to a consent order, settling the amount for the amount of the claim. This was clearly an obvious error, and it clearly obtained Chamberlain's client a benefit which has no supportable foundation in law or fact. Not only was the settlement reversed, but Chamberlain was suspended from practice for 6 months. Serious business, this ethics stuff. So at the end of our second video this week, what have we learned? First, we owe one another the duty of courtesy. Our opponent is just our opponent. They're not our enemy. Second, if our opponent makes a really obvious error which will give our client an unfair advantage, an error which will deprive the court of the opportunity to do justice, then it would be unethical to take advantage of that error. In the final video this week, we'll look at one specific type of error, our ethical obligations if an opponent inadvertently discloses some matter to us. See you in video 3.